Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Hello. Sorry I'm a little bit late. I hope everybody is doing so great. We're gonna jump right into court. I will not further comport or purport. Hi Ronnie. Hi Vicky. Hi everybody. Happy Saturday. Happy Pie Day. It's not Friday, but Pie Day. Anyways, I hope everybody is doing so good. So good. Let's travel by some floozy powder. What kind of fish usually goes in fish? Oh my god. Okay, so apparently the last time we were here, I was up in the middle of the screen, And I was smaller. I like being a little bit bigger. Anyways, but not that big. Not quite that big. This big. This will be perfect. Oh, pizza pie is a very good kind of pie. But I think the type of fish that usually goes in fish tacos is tilapia. I don't know. I made it up. I made that up. Casey Carey, moving into a new apartment. I'm so excited for you. And jealous. You don't even know. Anyways, you baked a chocolate cake for Pie Day, Loretta. That is amazing. I love it. Hello, Erica. Hello, Courtney. Oh, was it Groupa? It's Groupa. Anywho, let's continue. Oh, Loretta, you're pink on the chat screen over here. Around here, that gets you nothing except bragging rights. Anyways, we are going to watch a little bit of small claims court. It's pretty fresh. Pretty fresh, I'll tell you that. Just got her today.
We're going to begin with
We are. That's right,
the
Judge.
case.
We gotta call
All right,
him
so
Judge
that
Pause.
so we'll do that. Case number 39430. That's the Bakers against the Martingale Apartments, represented, it looks like, by Stacy Lemons and Julia Mott. Okay, so as I mentioned before, the process is going to work like this. I'll swear in the parties, and then I'll start with the plaintiff, who does have the burden of proof in the case to demonstrate why it is it's called preponderance of the evidence, which is a fancy way of saying more likely than not that they're entitled to the money that they claim they are legally entitled to in the claim, the notice for a small claim. So the plaintiff will make their case, and they'll turn it over to representatives from the defendant for their position. And then I'll make a ruling. Again, these are informal proceedings, so while you will be sworn in and be providing testimony, know that this is also primarily an opportunity for me to ask questions. This is more of a conversation as well, because it's, again, I'm trying to understand what happened here myself. So before I swear folks in, I do want to give parties the benefit of where I'm at as far as my review of the notice of claim, as well as materials that have been provided. And before I start that, I'm going to toggle over to your file.
love my Instant Pot and I hate this judge. I love
Okay.
my Instant
So
Pot and I hate this
what
judge.
I've reviewed here, and my understanding is Cody and Esmeralda Baker are requesting the return of their $500 rental deposit. My view of the documents indicate that the Bakers had moved out of the defendant's apartments on September 7th, 2025, after a year lease. They're claiming that the apartment had no damage outside of normal wear and tear, and are claiming that they have been charged an additional $400 for carpet repair, $200 for parking spaces. They don't believe that they owe. It sounds like there's been some disputes over whether the Bakers were able to get copies of their lease and other documents from the Martingale apartments that would help them in their claim. So I do have a few follow-up questions based on my review of everything, but I'll let folks start to provide their testimony, and we'll again interject with questions as we go. So for the Bakers, if you could both, I understand you're kind of sharing a seat there. If you can try to both get on camera.
Both get on camera, that's what we like to see. Casey Carey 3. Actually, I bet there's other numbers after that. But thank you so much for having a live, your first night alone. You're not alone, you're hanging out with us. That's not even alone at all, dude. Also, hi Mikey, thank you very much. I'm glad that you and Creed were able to do your show tonight. I know everybody's worried about Creed down in Florida. People do get into trouble down in Florida. Cellulite yoga pants, that's okay. Your lateness is excused. Excused. Oh, there's my lover, Timu. They just are desperate. Desperate.
To the best you can, and raise your right hands. Do you both swear and affirm that the testimony you're about to provide is the truth and the whole truth?
Yes, Your Honor.
Yes, I do.
All right, go ahead. Whoever wants to speak first can go ahead.
Your Honor, you are a little hard to hear. The volume on our end is all the way to max.
All right, I'll move my mic a little bit closer. Can you hear me all right now?
Yes. So again, we had moved out. We provided a 20-day notice to vacate. We purchased a home in Chehalis. We received instructions to leave our keys in the apartment after we vacated. So we provided notice, cleaned the apartment to what we feel was a move-in ready condition. The carpet had no damage beyond maybe a strand or two protruding from the bedroom. The apartment is mainly laminate except for the two bedrooms. And so we asked for our lease, our application, and our ledger, as well as any statement of charges. The Martingale Apartments kind of kicked that can down the road multiple times. It was very hard to talk to someone over about a month and a half period. By the time we were able to get our documents, they said that the PDFs were too large and that it was going to be on a resident portal. But by that time, our portal was locked. We asked January for those documents to be, or excuse me, for the portal to be accessible to us. They never responded. So we went ahead with serving them what we believe to be all the relevant documents, and submit all the evidence which you've already read. They also submit us to a collections agency while this court case was pending. And so that's a matter for another time. But we feel that we are owed our deposit back, or their charges at least be waived, is what we feel. We feel we dealt with them honestly. We never had any complaint, always paid our rent on time, and had a good working relationship with them. And this is a common practice that Martingale does based on other public responses, specifically to carpet.
All right, so a couple of questions for you. I just want to clarify. So the amount you're requesting is $500, the $500 deposit back. Are you saying that you were charged an additional $400 on top of the rental deposit, or are you saying that $400 for carpet repairs was sort of unjustly taken out of that rental deposit and you should get the full amount back?
I'm saying that the charging for the carpet was unjust, and for them to use all of our deposit was unjust to begin with, because we left it spotless. They didn't even charge us a cleaning fee because we left it so spotless, is what one of the managers told us. So it's the filing fee plus our deposit back. If those numbers are off by a few dollars, I would understand.
And then you also claimed, talk to me a little bit about the parking spot. So you say you paid $80 per month for 2 parking spaces, and then were charged $200 for parking spaces when you moved out. So were you paying $80 per month for 2 parking spaces, or $80 per parking space?
For $80 a month for 2 parking spaces. So $80
Total. Okay.
total is what we paid during our lease time. We then, when we moved out, we paid our prorated amount, and then after we moved out, the final statement of charges had a $200 charge for parking on there.
Okay. All right. Thank you, Cody Baker. Esmeralda Baker, anything to add?
No, nothing to add.
Esmeralda.
All right. So turning over to Stacy Lemons and Julia Mott, if you could both please raise your right hands. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
All right. And are you able to hear me okay?
Yes, we can hear you.
Okay. All right. And before we get into your testimony, do we have any updates on mediation? I see some.
Yes, Your
folks-
Honor, my case is 39302. They would like to go to trial this morning, or whenever you're able to get to it.
All right. Thank you. Appreciate your time this morning. All right. So the folks for Miss Barraza and JetBlue, there's going to be 2 trials ahead of you. So if we get to you this morning, we'll have that trial. But we're just starting the first one of now 3. So we'll do our best to get to you. All right. So hang tight. All right. Representatives from the Martingale Apartments, you are sworn in now, and go ahead.
Yes, Your Honor. I did just want to make note here real quick that when we received this notice, we only received a 1-page, like just a front page document. And it's sounding like we should have had additional pages that told us like that we were supposed to submit paperwork ahead of time. So I have all of our documentation, but I was not aware that we were supposed to submit that with the court. In regards to the case itself, with the parking charges that Mr. Baker is referring to, I did discover that the charges were incorrect on his original financial move out.
I did not, hold on, ma'am. I did not lighten my hair. I just washed it. It's amazing what water does, and soap, Hector. Also, link to KCC's Discord. Thank you, Cellulite Yoga Pants. You can't hear me? Now you can, right? Is it just Hector that can't? Anyways, I'll just shut up anyways. Anyways, I don't know. I'm worried about the unscrupulous landlord sometimes. I have too much calcium in my hair. Maybe.
And then I revised that. I did send Mr. Baker an email telling him that on October 24th, 25. I said I did identify an adjustment needed to the covered parking charge, as it appears the system did not properly prorate that amount. This correction has been made and has reduced your balance by $66.68. An updated final move-out statement reflecting this adjustment has been sent to you directly through Entrata, which is our property management system. So I did know about that. I did correct that, and that was all corrected in the month of October. In regards to the move-out date, Mr. Baker is correct. They did provide a proper 20-day notice, and that 20-day notice was stating that they would be out by September 7th, 2025. On that day, we did not receive confirmation that they had vacated the home and left the keys in the home. We did not discover that the unit was vacant with keys returned until September 10th, 2025. And so we did charge through the 10th of September.
But where
we
did you find the keys then? Stacy? Huh? Stacy?
Provide, whenever somebody gives a notice to vacate, we provide a move out handout that alerts people of how they can return their keys. And one of those options is leaving it in the home, but it does state that you must still alert the office that you have been vacated or that you have vacated. Our stance is that we are not allowed to enter an occupied home. And so until we are sure that somebody has vacated, we do not enter. In regards to the unit condition, the only charge that was present for damage was carpet charges. The carpet was new at the time that the Bakers moved in. It was replaced July 1st, 2024. That was 7 days prior to their move-in. And then once they vacated, we do have a professional carpet company come out and evaluate all of our carpets to make sure that we have a third party that's doing this evaluation. They did find that there was urine in the carpet. And Mr. Baker is correct, there was only carpet in the bedrooms. The carpet was then subsequently replaced on September 12th, 2025, so 2 days after the move out. We did charge a proration of the carpet. We put a loss of use of 26 months for a total of $393.48. However, when I've done the math again myself, it was actually 46 months of loss of use. It should have been $912.02 that we charged. Now that was our mistake and our error, and as our charges should have actually been higher, we did leave that at the lower amount that we had already discussed. And so we do feel that this carpet charge was accurate.
Okay, so the carpet charges were done. You said there was a company that came in, sort of a third party that comes in to assess the condition of the carpet and make recommendations as to cleaning and replacement, things of that nature.
Yes, correct.
Do you recall what company that is?
Yes, that is Acumen Carpet Cleaning and Resurfacing.
Okay. And so Acumen provided Martingale with a, you said, talk to me a little bit about the loss of use for a number of months. What does that mean?
So we will prorate carpet. We base our carpet off of a 60-month lifespan, which is 5 years. And so when we need to charge a prior resident for carpet, we always prorate that carpet out. And so if we have our lifespan of 60 months, however many months of use we lost is what we then subsequently charge. So we charged the Bakers 26 months of loss of use.
Okay. And that was based off of Acumen's assessment?
That is correct, yes.
And that assessment, you said it was based on, sounds like urine stains on the carpet. Was there anything else that you mentioned I might have missed?
No, there was like one fray, that was not a main concern. The concern is the, urine, which can be difficult to see in the carpet, but I do have, pictures of the backside of the carpet. And that's really where you can see that there was, urine that penetrated through the carpet. And then Acumen themselves takes photos of, all of this, and they have like a camera, and it will shine red, or like a probe. It'll shine red when there is urine present, and I do have those photos.
And to clarify the amount in controversy here, were the bakers charged an amount in excess of the $500 deposit?
Yes, that is correct.
right.
So their total outstanding balance, is $333.44, and that is after the use of their $500 deposit.
Got it. Okay. And Miss Mott, or yes, is Miss
Yeah.
Lemons there? If you're the one that's been testifying?
Yes, Ms. Lemons.
Oh, Ms. Lemons
All
has
right.
been.
Miss Lemons. All right, Miss Mott, do you have anything to add?
No, everything that Ms. Lemons has said is accurate.
Thank you. All right, I'm just going to take a look at a few documents in the file here.
Is the judge having a sample of the carpet sent over? We gotta call him Judge Pause, I think. Judge Pause.
All right, back to the bakers. So you've had a chance to hear from the Martingale Apartment representatives. I know you've also sat through mediation, so these all may have been things you've already heard, but I'll give you a chance to respond, as this is your petition. So go ahead.
Yes, Your Honor. As far as urine in the carpet goes, we always took our animal outside. I deny any urine or even significant urine stain, even if it were to happen, beyond my knowledge. The other than that, they admitted that there was only a small fray in one of the bedrooms, which really just means like a strand or two. So to me, that's that's not beyond normal wear and tear. They did not charge for cleaning because we cleaned so well. So I mean, I also don't understand why they used all of our deposit anyway. If the only charge was $393, we should have had some left over anyway, just for argument's sake.
All right. So a couple of questions for you too. So so you've got the burden here, right, to show it's more likely than not that you're correct and that you are owed the security deposit back. And I'm not an expert in carpet repair, carpet cleaning. Again, I haven't seen the apartment. And so what Martingale has provided, at least at this point, is testimony that they talked to this third-party carpet expert who comes in and assesses the quality of the carpets and makes a determination on kind of what's needed there. is your testimony and kind of your view, is it based on your opinion? Were you able to talk to anybody? Did you go out and talk to carpet folks about whether this is a reasonable charge, anything like that?
Carpet folks.
I didn't talk to
calling all
any
folks.
carpet repairman. I did talk to my personal attorney who reviewed the photos they sent to the collection agency and advised me that it wasn't anything beyond normal wear and tear.
Okay. Is your attorney have any expertise on that front?
No, he's a real estate attorney who deals with unlawful detainer. That's about it.
Well, it does sound like there are some there's some photos and some documentation that's out there that Martingale hasn't provided, and so that I haven't seen. And it sounds like they may be photos and some documentation of the carpet. I understand the Bakers, you've mentioned that you were trying to access some documents too, that you were having some trouble doing that. I mean, we can resolve this today. We can also continue it and give Martingale some time to, submit some photos to the court, so that, we all have benefit of kind of a fuller picture of what's going on here before making a decision. Because again, I don't have any photos in front of me. I've just got the allegations and some personal opinions about whether or not the carpet damage was appropriately assessed. So that sounds like there may be more information out there that could be useful. But for the Bakers, I understand, this is your petition, and this would be sort of a continuance for the defendant respondent here to file some more documents, although it sounds like it might be helpful to get some photos before the court. Do you have any position, Bakers, on continuing this out, give Martingale some time to upload some photos?
When we went to the post office to send all the documents certified mail, I understand they're saying they only received one paper, but we provided everything in the instructions to them, and they via certified mail, and submitted that receipt.
Yeah, and I'm not saying you did.
So I mean,
wrong. Saying there's more. It sounds like there might be more information out there that would be useful. Again, these are informal hearings.
Sure. I'm just saying they've had time. They've had time to submit those things.
Well, and what I'm saying too is, it may be in your best interest though to allow the court to look at pictures, because again, I'm not an expert here. If I can't see photos of the apartment, I've got really nothing to base my decision off of, except for you're saying you don't think the damage reflects the amount that the apartments are saying. The apartments are saying, no, this is accurate because we talked to an expert. And that's at this point all I have to go off of. And so, I understand that you did what you were supposed to do as far as service is concerned. But at the same time, I think it's in everyone's best interest to have as much information before the court as possible before making a decision, especially when we're being asked to make a call on the quality of something and I can't see it. And I don't have any expertise in this particular area. So with that in mind, again, I'm happy to make a decision today, but at the same time, I want to get your opinion on whether you think it would be beneficial to you to reset this and give Martingale a little bit more time to upload some photos.
I think it's worth just proceeding with a judgment with the amount being so low. 390 or the damage that they're
Bro, the judge
seeking
just
as well.
told you that's not a good idea. He just said you should wait. That's what he said. You're choosing not to hear that. I don't think that's gonna go well.
I think it would just, time, cost, and effort just to settle this today.
Okay. All right. Well, and to be clear, I can't, you're the plaintiff here, so I can't, it sounds like Martingale is saying you owe $330 total and 44 cents. That's not on the table here. All this is whether or not you, the Bakers, get your security deposit back. That's the only thing before me today. Sure. And so, all right, well, I appreciate your comments there and kind of looking at that with some clear eyes. So I'm going to kind of rule in favor of Martingale Apartments. I don't believe the Bakers, I don't believe you met your burden of proof here that the $500 is owing based on what I'm hearing. So again, I'm not saying you owe what Martingale Apartments is telling you owe, but I'm saying that I don't think at this point legally you're entitled to that $500 security deposit back. So with that in mind, I will fill out a small claims judgment indicating that case is dismissed following trial. And I wish you all best going forward.
Thank you, Your Honor.
Thank
Thank
you.
you
Your
all.
Honor.
See, where I live, I think that it's in the flip that you have to prove why they don't get their deposit back, not the other way around. I don't know about that. I don't know. Judge, he's the pauser. He pauses. all
And
the
Connor
time.
Klein and Trinity Townsend.
Connor and Trinity. What a name. Well, two names.
Right.
Oh my
And
gosh, that's not what
Connor
I was
Klein
expecting of
and Trinity
Trinity.
Townsend, if you could please come off mute and activate your cameras. Trinity Townsend, do we have you? There we go. All right. Just gonna open up your file now too. All right, so similar to the last case, what I'm gonna do is I'm gonna start by just giving a brief overview of what I've reviewed and where I think we are on the case, and then I'll swear you all in and hear from both sides. So Miss Iceland filed a notice asking for $8,275, indicating for rent, late fees, damage to property,
Whoa.
and utilities. Documents I've been able to review include a written lease, let's see, dated April 16th, 2022. That ran a year. Then there was a 12-month extension going through April 30th, 2024. Another extension going through April 30th, 2025. It appears to me that the alleged amount owed is after that final lease extension of April 30th, 2025. So one question I have as we get started here is the status of the tenancy after that, I guess, May 1st, 2025 moving forward. And I have a couple other questions, but generally speaking, that's my picture of the status of things. I see there's looks like the lease indicated a security deposit of $1,500 as well. That's been applied, or that is part of the lease agreement. So I have questions about that as well. But that said, Ms. Iceland, if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
All right, go ahead.
Let me talk.
Yes.
Okay. So Your Honor, this court case was filed on December 26th. And per the court rules, I filed documents in a timely manner 3 weeks prior, 3 weeks ago. This small claims is actually not for any damage or the $550 water garbage bill that I've been left with, but it's only for rent through approximately the 1st of December. The
This year or 2025?
correct,
Okay.
Your Honor. The defendants have discussed this. I've discussed with the defendants this case, Your Honor, on several occasions. They had the ability to file the documents prior to today, and they failed to do so. Plaintiff Trinity Townsend had gone back and forth between the rental. Several times when I went over to there, she was there at the rental. I've got numerous text messages where they've talked about, well, I never knew when she had actually moved out. The individual, the volunteer, had asked her to send a message to me as far as some conversation that we had, which I did not get, but so for like the last 6 months or so, it's been a back and forth with text messages that I have showing where Trinity Townsend and Mr. Connor Klein were going to get back together. Then she was going to move into the rental and he would move out. The rental was on a month to month, was the last time that we did an extension of the rental lease. It stated month to month thereafter.
Okay, so after starting May 2025, they went to month tenancy?
Correct.
Okay.
Yeah, and it states that on that, the one extension that we did that was dated, the last extension in
The
March of
final one.
24.
Okay.
So, and you know, as early, as late as in November and December, and even January, Trinity acknowledged that, you know, she had keys to the rental. She, I don't know if she lost one or what happened, but I gave her another key. She was talking about going in and getting all of Connor's stuff out of the rental since she was still on the lease. I believe she started to do that, but from what she has recently told me, he has had some abusive issues. Again, in the last 6 months, it's been, okay, she's gonna move back in,
Allegedly.
he's gonna move out. They're gonna work things out, text messages where, oh, she's gonna help him pay the rent. And so it's been a back and forth thing for the last 6 months. And when I filed this, I of course didn't have any idea as far as the massive amount of damage. So there's really no damage on, I'm not asking for any damages at this point, or, you know, even the extensive water garbage bill, but just basically back rent owed, which is itemized just through the beginning of December. They did have they had paid 1 month for last month's rent, hence why I did not include any rent since December on this.
All right, so the the amount in your claim, the 8,000 and change, that's still the amount you're requesting, but that's just back rent.
Correct. I mean, I don't know if it's appropriate or not to ask for a modification for it to specifically say that it's just back rent, because the property is massively damaged and this is no, there's no damage assessed in this. And when I actually figured it out for the case for the filing 3 weeks ago to make sure I submitted my documents, the amount that came out that was actually due, and that's just, I believe, excuse me, that actually had January on it, but
Getting gifts from Shane. Shane, thank you so much. I love it. Thank you so much. This lady seems well put together, but she's asking for a lot of money. How much was their rent? That's my question. Yeah, William spotted. Is that? No, it's not tie-dye. No. Thank you so much, and welcome, Hector. We do members only tomorrow, Sundays.
I took it off. That was $10,998, and I only put down the $8,200, you know, hoping that this situation would be dealt with and the unit would be vacated. And at this time, there's still a motorcycle in my garage, so I can't even like rent the unit, like prepare it to get it cleaned up. I've got lots of text messages that I can show, and I also have, you know, photos and stuff too. But right now, my unit, the middle of March, is still sitting there with massive debris. The other stuff was removed, but it's still sitting there. So this is still a situation I'm trying to deal with.
Okay, no, so that is helpful because understanding what when you ask me, you know, for you know, to find in favor of a certain amount of money, it's helpful for me to know why that's owed, because then that helps me frame, you know, what is the legal authority for you getting that money. So that is, if you're asking for that for back rent, then I'm looking at, you know, tenancy issues versus damage. I'm looking at damage issues.
Okay,
So if this is
thank you.
just for rent,
Just
that helps
rent,
me
Your Honor.
focus in what I'm
Okay.
looking at. Okay.
If it's appropriate to amend
Yep.
it just
No.
to say for rent.
No,
then-
that
okay.
you don't have to amend anything. That's
Okay, thank you,
helpful
sir.
for me to know.
Okay.
Okay. And so it sounds like this may be a more complicated question, but who's the tenant now? Are they currently still tenants? Are they both
Well,
tenants?
as of approximately the 1st of March, Connor Klein had left his key. He said the only key he had, he left it on the counter, even though, and he said he had gotten all this stuff out except for his motorcycle. So, and then Trinity had said she would go in and she would help me do some cleaning and stuff, which she wasn't able to do. And so again, it's a sticky situation because, you know, they've been going back and forth in their relationship apparently for, I don't know, the last 6 months or 7 months. You know, getting together, both of them being there, her not being there, her renting an apartment. Apparently, she said she's had it for much longer, which, you know, I didn't even realize, but it was always, she was gonna move into my apartment, he was gonna move out. So it's been this back and forth with numerous text messages.
And is Trinity staying there now? Is she living there?
No, as of right now, no one is there. And, you know, she does have a key. I think she said that she had lost the other key, but she has a key that I gave her approximately a month or so ago. Because she was, you know, she didn't want to be accountable for all the damage. There was an enormous amount of damage. And I actually said to her, I'm not going to go after you for the massive amount of damage to this unit, even though they had a dog there together. This is just about rent.
Okay. All right. And so this sounds like this went to a month, and then as of
Correct.
the month of March 2026, they're no longer formally your tenants, but they've got some.
I believe so. And I need to probably consult legal, but I believe since he turned over the key and she said she does not want to be on the lease, I believe I'm okay to probably, you know, clean my unit and deal with my unit. But at this point, I have not removed certain things from the garage that are still
Okay.
his.
All right. And then looking at the itemized breakdown of the rent, so that I'm clear.
Yes.
And I haven't done all the math here, but what you're saying is between May of 2025 and December of 2025, there's a breakdown here of rent and late fees. Are you saying that the 8,275 number comes from the back due rent?
Through about November.
Through about November. Okay.
Yes, correct, Your Honor.
All right. So all the allegations about what's owed is here on the
Correct.
the debts portion of 2025.
Correct.
Okay. Thank you, ma'am. All right.
you, sir.
So looks like Ms. Townsend and Mr. Klein are in different places. So what I'm going to do is I'm going to hear from you both individually rather than at the same time. I think that will just help keep things a little simple. So first up on my screen, at least I see Mr. Klein. So Mr. Klein, I'll have you raise your right hand, please. All right. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay, so go ahead. And again, it sounds like there's been a lot of issues, you know, some alleged damage to the property, things like that, some issues with the motorcycle still being there. To help focus comments, you know, what you just heard there from Ms. Iceland is the only issue before the small claims court here is back rent from when this was converted into a month-to-month in May of 2025. And so it's helpful for me as kind of the fact finder here to just hear about that. So hear about allegations that there's, you know, $8,275 due in back rent starting in May of 2025. So go ahead.
Trinity, she moved out November 24, like she said. So she hasn't been there. The only reason she was ever stopping by is I was watching her kid, and so she wasn't living there that whole time, this whole back rent thing. So that's on me, 100%. And I was on and off jobs. So yeah, I take responsibility. I don't remember signing another lease extension in 2025. I think it's been a while since I've done that, but I don't know. I think that matters, but
okay.
Yeah.
Are you the amount alleged here, the 8,275 in back rent? You saying that's an amount you feel you owe?
I have no clue, and I feel like that is a little high, but I have not done the math either, and to be honest, I haven't really looked into it at all. So that is, yeah, I had no idea.
We can do the math here, because I have got it itemized in front of me.
Yeah,
And
but I would, I'm sorry.
that's all right. And we can do that here quickly. That's easy enough. Are you saying though that if the amount here that's itemized in back rent works out to the amount owed, you're sort of acknowledging that's an amount you owe, Ms.
Uh-oh.
Iceland?
Yeah, well, I mean, I made small payments here and there, and I like it could have been over like Cash App or in person, and I just don't know the exact amount. Yeah.
All right. So a couple of things. Well, I appreciate your candor, sir. And just so you're aware, so everyone's comfortable moving forward, I do have it sounds like you're not necessarily disputing that this became a month to month, but I do have in front of me the final lease extension dated March 5th, 2024. Looks like signed by yourself, Ms. Townsend. It does indicate that the lease at the time would be in effect from May 1st, 2024 through April 30th, 2025. And then it provides and a month to month thereafter with rent at $1,620 per month, pet rent an additional $35 per month. So it does look like that's there. Okay. Well, Ms. Townsend, I mean, I'm happy to swear you in if you'd like to testify as well, but it sounds like Mr. Klein there is indicating he's sort of taking ownership of the amount wasted. So
I mean,
again, I can swear you in if you want to provide some testimony, but if not, that's fine too.
I mean, I just would like to state my case just in case this does like end up, I know he's taking responsibility, but I would like to state my,
All right. If you please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Okay, that's fine. So yeah, you're welcome to address the court. Again, though, you know, I want to caution you to just keep your comments associated with the issue of back rent.
Yes.
Okay, go ahead, ma'am.
Okay, I was just wanting to state that, yes, I did move out November 1st of 2024. I had moved out and gotten into my own place for personal reasons that don't need to be discussed. But yes, I did leave with my son, and she mentions me being at the property, and that was just because, like Connor has mentioned, because we have my son that he has been helping raise for the last 5 years. So there was no reason for her to indicate because I was there that I was living in the unit. I had made it very clear on the 17th of November, 2024, that I had moved out and that she could use my deposit to pay use that towards anything owed, and that I wanted to be removed from the lease, but she never removed me from the lease. And when I last met with her, she provided copies of all the the lease agreements, but she never provided the last one. So I don't even know, I'm sure you have it, but I was unaware that it was month to month because she never provided me a copy with that one. So had I known that, I would have asked her to again, I would have gone to court to remove myself, since she refused to remove me off the lease when I had asked her to, because I had no intention of moving back in unless he moved out, and that's all I had mentioned to her. And I know we have text messages saying that if he ever moves out, that I'd like to rent the unit again, because I do miss living in a unit with a garage, but I had never moved back in. So that's all I have to say.
All right. Thank you, ma'am. All right, I'm going to do some math here.
And I do have a copy of my new lease that I had moved out to as well. So with my new rental.
Okay.
I'm not really sure how that's relevant because you can have two
Can I say
at
something, Your Honor?
once. But
Sure, go ahead.
what?
One of the things that made this a real kind of a crazy situation is Trinity Townsend said that her lease would be up in the end of September, so she was going to move back in. Her and Connor text messages stating that, you know, they'd gotten back together, they were hanging out and celebrating her birthday in August and September. He was going to move out, she was going to stay on the lease. So yeah, it was a crazy situation where, you know, he works underneath the table, so there's absolutely no way I would be able to, you know, follow through on just him. he himself has said in text messages and to her, you know, I'm gonna make sure I damage this unit as much as possible because you're on the lease and you're gonna be responsible for it as well.
All right. So what I understand some people want to make records about some of the more dynamic issues in this arrangement. I'm going to just kind of stop us here though, because I think we've reached resolution at this point. You know, this isn't necessarily a forum to kind of get into
We're
some of that
coming to
other
completion with the
stuff, especially
unit.
since, you know, these are informal proceedings, but we are on the record and folks are under oath, and I don't want to wade into territory that's not relevant to the issue of the small claims judgment. So I'm going to find in favor of Miss Iceland in the amount requested. That amount is going to be owed. I'm going to dismiss Trinity Townsend, given what we're hearing today as defendant number 2. And so we'll reflect that in the judgment.
She was staying there, Your Honor. She was going back and forth.
No, I was not.
But it sounds like Mr. Connor or Mr. Klein is taking responsibility for the amount owed. And so we're going to have a judgment against him.
She mad at Trinity. Trinity. Who wants pork carnitas
Right.
for dinner?
And so, yeah.
Does it matter, Your Honor, if the reason he's making this deal to agree that she shouldn't be responsible is because she has a protection order against him and she will release that protection order if he does
Again,
this?
this is the kind of
We
thing
do
that
not
we're
have a
getting into
protection
today.
order.
Yeah, these are the kind of things we're not getting into. All right.
There's literally no protection.
Ma'am, you won. Why are you being like this?
All right. So, ma'am, is going to be $275. Filing fee.
That's just my regular size joint. William.
And
That's just regular.
do you have information on?
It should be filed there for the service, Your Honor,
Yeah.
$50.
Oh, there it is.
So-
Yep. Okay.
So is there no like obligation to the fact of the court filings and like no documentation was provided as of this morning?
Ma'am, you
for the
won.
I thought it was real important to make sure that the paperwork got filed so people could respond.
What are you concerned about? You're
Well,
ruling
I'm-
in your favor. What's the issue?
Well, because I'm very concerned about not having Trinity on it when, if she had specifically said to me, I'm not gonna be there rather than this back and forth, and she was going there and, you know, having it just be on him.
Oh, I see.
He works under the table. There's-
Okay, I see the issue. I'm sorry.
And, and that's why I didn't end the lease because I've got text messages of her saying, you know, oh, I'm in September. And so
All right.
she has a job that she actually works that's above
I
the
understand.
table.
I understand what you're saying.
It's very,
Okay.
and I told her there's about $10,000 in damage. And I told her, I'm not gonna go after her, even though she hogged there, which did massive damage, another issue. And floors had to be ripped up. I'm not going to go after her for any of that $10,000 damage, but she understood that she was gonna be accountable.
All right,
for
I
part of the
understand what
rent,
you're
Your
saying.
Honor.
Okay, thank you. All right, I understand. That's helpful to know. All right, so, so Ms. Townsend, similar to Mr. Klein, what I have in front of me is again, that lease extension dated March 5th, 2024, which looks like you did sign. And it says that, it indicates that this is a lease extension and agreement between Elizabeth Iceland and the tenants, Trinity Townsend and Connor Klein. As discussed with the above persons, the lease will be extended for 12 months, May 1st, 2024, April 30th, 2025, and month to month thereafter. Rent is $1,620 per month, pent rent an additional $35 per month. Now, when are you, Ms. Townsend, when are you saying you were no longer a tenant?
I moved into my apartment that I live in currently, November 1st, 2024. I notified her on the 17th of November of that year that I had moved out and that I wanted her to take the deposit and keep it because I had left and that I no longer wanted to be responsible for the unit. But I said that I understand if there had been damages prior to me leaving that date, that that was what that deposit should go towards. But I didn't want to be responsible for the rental anymore. And then there has been messages between us over the year and a half that I've been gone where I told her if Connor was removed from the lease and they ended their lease, that I would be willing to re-sign a new lease with her, but we never re-signed a new lease. I shouldn't be responsible for the months that he's been living there by himself. And she keeps bringing up the fact that I'd been there, but like I said, I'd only been there a handful of times to pick my son up because he has been a stepfather to my son and helping raise him while I'm at work. That is the only reason I was ever there. I never lived there. I have a whole 2 leases that I've signed at this rental that I live at now, where I've been living here every single day. I stay the night here every night with my child. I've never lived in that unit since November 1st. I moved out October 31st into this apartment. So I don't understand why she's trying to make me responsible for back rent that's been from 2025 on, when she should have removed me from the lease multiple times when I had asked her to. I never asked her to take over the lease. I said I want to sign a new lease if that were ever him leaving, because I wanted to have a bigger house eventually again one day. But I don't feel like I should be responsible for his back rent. He stated that I shouldn't be responsible for it because he's agreeing I have not been living there. I can show proof of my rental here. I live at Deschutes Cove Apartments in Tumwater. I've lived here. It's low income. I've lived here since November 1st, 2024. And I understand her concern with everything, but I don't think it's fair that me as a single mother be responsible for back rent due while I'm also trying to take care of my own place. Like, I didn't live there, so I don't see why I'm supposed to be responsible for not.
Well, so, okay, so Miss Townsend, one of the issues is, I hear what you're telling me. I don't have anything in front of me indicating any of this. And so, folks are, we do have a rule as part of this process. If you want the court to look at things, you got to file it with the court.
And I
Otherwise,
wasn't aware that I had to do that. She just told me that she filed and that she said you just have to go to court, and that she was trying to like work out a deal with me, basically telling me if I move back in that she would take me off the claim. So she was trying to basically blackmail me into moving back in.
So Ms. Townsend,
take
the
over.
problem though is, so I understand. It's not the petitioner's job though to educate defendants on kind of what they need to do on the process. When you're served notice of a small claims judgment or claim against you, at that point it sort of becomes on you to respond.
Well, I didn't even get notified of it. The only reason I was notified of this was because of him, because he told me that there was she never sent me any paperwork, just him. So that's where I'm like confused on how I was supposed to even be notified, because had me and him not been in contact at all, I would have never known that there was even a notice filed against me, because he sent me pictures of the paperwork. I didn't get anything in the mail stating I had court. Like, he was the one that had to tell me, oh, the landlord has been serving both of us. But she only served him, not me.
Both of them were served, and she even called me and told me that she picked up her packet of paperwork at that rental.
No,
and that was
he gave me the
January.
Paperwork because I had to get it from him, but you didn't serve me directly.
That's correct. I served you at the residence.
I was not at the residence.
Who lives at 1419 Phones Road?
Me. That was me.
Well, both of them.
I do not live there. I live at 7201 Henderson Boulevard.
Connor could solve all of
Nothing
this.
was ever given to me. I've moved out as in October, they were talking about, oh, we're going to get back together. I've got text messages from saying Trinity's helping, even though she's not here very much. She's going to help with the rent. We're going to work this out, but we have to wait till October till her lease expires at the other location. Okay. So it was like a back and forth, and
There's no text messages from me regarding that.
October, they were saying that oh, they were gonna work this out, they were gonna get back together. So it kept going on this month to month.
I asked November 17th of 2024 for you to remove me from the lease. You did not. That is not my fault.
Well,
All right, so here's what we're gonna do. So we're not gonna make a decision today. There's a lot more information we need to, and what I am seeing on the certificate of service, it looks like defendant Trinity Townsend was served on a Phones Road address received by Connor Klein. I don't have any information on where Miss Townsend lives, but I will want to, if they don't live together, then we're going to need proof that both have been served. And because it is indicating on the proof of service that Connor Klein was the receiving party at this Phones Road address. And so, and again, these are informal proceedings in the sense that we do just want to have all the information before the court. And I do think, given the status of a month-to-month lease, if Ms. Townsend has information indicating whether or not that continued, I think that would be important to see. So we're gonna reset this then. I do want to see proof that Trinity Townsend was served separate from Connor Klein.
she was served at that residence, Your Honor.
I was not.
And she even called me and told me, I got the packet of paperwork from the rental. She specifically told me I got it. Plus, I gave her information when I met her 3 weeks ago when she
You
was
gave
gonna
me-
come and help clean. I gave her information regarding this court proceeding prior to the deadline for her to file any documents in this case.
That's
And
not
at that
legal
point,
service,
I told
though.
her, because there's as much damage to this rental as there's loss of rent. And I said, I will not ask you for any of the damage, the massive damage to this rental. You know, if you're are accountable for the rent, because the rent is only half of it, Your Honor. And she was there, she knew that the dog was, literally pooping all over this rental and the damage it was doing. She knew about this. I've got massive photos to show. And I said, you never said, okay, I'm gonna for sure move out, and no, I'm not gonna move back in October. It was this back and forth stuff.
November
So it
17th, I
continued-
told you I moved
So-
out.
Right,
That was
so
over a year and a half
we're
ago.
We're gonna address it, but I think that actually is the crux of it. If she can show that email, it doesn't really matter if she may not, I don't know. I think that there's a legal basis there where giving her notice like that to break the lease, she certainly can't renew it with her on again, which is what I think what happened again at some point.
Address this at a later date. That's what we're
Yeah,
gonna do.
that's a great idea.
I understand what you're saying, ma'am, about the issues with service. But if Ms. Townsend and Mr. Klein don't live together, I don't know if this reflects that she was given adequate service. And so we're gonna reset it.
Okay,
That's what we're
and
gonna do.
she knows obviously, because she is here
She's
on
here.
Zoom,
That's-
so she
that's
got
right.
the information.
That's right.
At the
But
time.
whether or not she's got the amount of time folks have to respond, I just think, again, I want to have the benefit of everything before me, before making a decision as to that 8,000 and change here. So we'll reset it to May 15th.
Okay.
And then, again, we're going to want to make sure Trinity, I understand you've got actual notice here of the hearing. But I think it's important that we have proof of service of the same small claims packet that you gave at the Phones Road address to Mr. Klein, that is also served on Ms. Townsend, so the court record can reflect that she has everything.
If I can find the text message where she says she picked up the packet, she has the packet.
I'm
and
not
she
saying
knows
that I didn't review it. I'm saying that he had.
But she
never
didn't
got
review
proof
it, but she
myself
got it, Your Honor.
directly. I'm
Right.
just stating that I was not given the proper information that tells me that I'm supposed to petition on my end against this. That's where I'm
Well,
saying.
so for that, Ms. Trinity, again, or Ms. Townsend, that's not information that you're necessarily entitled to. That you're supposed to defend yourself, right? So that's not
Okay.
the plaintiff's not it's not her job to explain to you what you need to do to defend yourself.
Okay.
You have to educate yourself on the process, right? And so then that's, you just go to Thurston County District Court website. There's a whole site on the small claims process, and it explains
Right.
what you got to do.
Yeah, but
and
like
that
I
includes-
didn't get my own packet. He got his packet, and he
Right,
did.
so and I'm saying you got to be served with your packet. I'm saying that, but the next steps as far as how to respond and represent yourself, that's on you. That's not on.
Yeah,
that's not
and I
on
understand that, but I just don't understand how I'm being still being held responsible for something when weeks
because
out had notified her I
You're
moved
not
out and that I
yet.
wanted off the lease.
The decision hasn't
Like, was
been
I
made
supposed
yet.
to file something with the courts saying that I needed removed from a lease? Because I figured that would have just been a conversation you have with your landlord, like, hey, whatever it takes for me to pay to get off the lease, I will pay that. And that was November 17th. Like, I don't understand how she just kept me on. And then I understand the back and forth with like me wanting to re-sign a new lease with her when he was removed from the lease, but he never got removed from the lease, so I never followed through with taking that into consideration with her because you know what I mean?
Townsend, if you keep interrupting the judge at a
I'm
small
sorry.
claims hearing, okay, you're not going to look very good when a judge decides how to resolve the case.
Okay,
All right. So you need to. I understand these things get heated, but when the judge starts talking, you need to stop talking.
okay.
All right. Resetting the case because you do need to get proper notice. So you're going to get proper notice, and then you need to figure out how to respond. And I'm not going to tell you how to respond, but what Miss Iceland has filed shows the last thing the court sees here is a lease extension that you signed agreeing to a month-to-month lease at that residence. And that's the last thing in the court file. So if that's what the court's looking at, if you have information responsive to that, then it's your responsibility to file that with the court when we come back here and take a look at making a decision on the back rent. Because right now, that's the last thing the court has is a lease extension that you signed saying it's that you're agreeing to a month-to-month after May 2025. All right. So we'll be back on May 15th at 9 o'clock.
Your Honor, I have no addresses for these people. I don't know where they work. Can I please get the information so that they could actually, like I could sign it rather than serving them at the residence? I could personally serve them. I have no information on where they're at.
And that's part of the process is you got to figure. I mean, the court doesn't help people serve process.
Well, because I didn't have her new address, she never gave me anything in writing. Okay, I've moved out for sure. I'm not coming back. The only way that I could serve her was by serving her at the residence that she was going back and forth to. And I served her, if you look at the documentation, Your Honor, I served her not personally. I served Connor personally, and I served her through the residence that I had on file, the only information that I had. And I have text messages where she said, I picked up the pack of paperwork when she was there.
We were kind of going back and forth on this now. There are other ways, the service rules provide, if you can't locate their residence, there are other ways to serve people, alternative service. And there are ways to do that. I can't give you legal advice on how to do that though. So you got to find her last known address. If you can't find that, or that's being withheld from you, there are other ways to serve people. And that's all spelled out in the rules. So we'll have to do that.
So I can't, so are you saying, Your Honor, that I can't have the address so I can?
Don't give
personally
it to
serve
her, but you already gave
I
it
just
to
wanna
her
have a firm
earlier.
All right, well,
understanding
Ms.
that-
Townsend, is there
I
an
can
address?
give it to her
where
right
you-
now.
Okay,
Yeah.
what's your address? Yeah.
720.
There you go.
And could I get an address for Connor?
You've served him.
Okay.
Yeah. So it's just service on Ms. Townsend now.
Is there a way to have an amendment on this, since amended claim on this, since I've told Trinity that I would not, Ms. Townsend, I wouldn't go after her for this other massive amount of damage if she could have accountability. Is there a way to amend it? Because since it doesn't include any of the damage to the property, it doesn't include the utilities.
Well, small claims court is maxed out at $10,000 and you're already right up against that. So
Is it for different situations? Because I didn't know of the damage at the time of the late fees.
it's $10,000 period. So that's all you get in small claims. If you want to file a lawsuit alleging more damages, you got to go across the way to Superior Court and file a.
In a separate motion?
Yeah,
Your
that's
Honor?
it. Well, they don't have small claim. This is small claims is allegations of owing $10,000 or less. If you're asking for more than that, you have to file a lawsuit in Superior Court asking for damages based on.
So can I just have an amendment on this that it's specifically for rent and late fees and no damage to the property, Your Honor? Since I didn't know of the damage at the time.
If you're well, you're already alleging in this. I mean, the important thing is you give notice to the defendants of what you're alleging. They should. So if you're going to allege back rent, it's important to make that clear. If you're going to allege property damage, they need to know what they need to respond to.
Yeah, at that point, I didn't have the damage it was only the outside and stuff and what the.
Okay. Then I would recommend filing. Can I do an amended small claims?
Yeah.
An attorney told me that we could
All right,
actually do
yeah,
that.
so you
if
can do that. So
appropriate.
it's important you can amend that and just be very clear what you're alleging they owe and why, so that they can respond. They have notice of what you're saying.
Okay.
All right. So we'll see everyone back on May 15th at 9 o'clock.
Thank you.
We'll be there. Don't you fret. Courtney, you still here? You
All right.
calling next? JetBlue's up.
And then last we've got Tiana Barraza, I'm sorry, and JetBlue. Okay. So similarly, what we're going to do here is I'm going to sort of go over my review of the claim and where we're at as far as kind of the allegations, and then I'll swear you both in and we'll go from there. So, all right, Miss Barraza is claiming $3,900.91 for reimbursement from JetBlue for a canceled flight, and then some damages associated with that canceled flight. So my review is that on July 31st, 2025, Ms. Barraza and her family had 3 tickets to Boston for a roller derby tournament for their son. And there was some, I think 4 delays throughout the day, ultimately resulting in the flight being canceled, an alternative flight being offered the following day. Ms. Barraza and her family elected to purchase tickets through, I think it was Delta, because the offered JetBlue flight essentially wouldn't get them to the tournament in time, and so they purchased tickets through Delta, and kind of because of the situation, I believe your son had to sort of travel alone, red eye, Ms. Barraza, and I believe her spouse went through, had to do a layover in Minneapolis, kind of got there later, and the allegations are the additional flight, ticket costs, Airbnb night, losing the car rental reservation as the damages. What JetBlue has filed is information from their contract of carrier, essentially indicating that when JetBlue cancels or otherwise fails to operate a scheduled flight in its contract, it indicates that what it will do is will offer passengers another JetBlue flight at no additional charges, or provide passengers with a full refund of their tickets, and otherwise is not liable for other types of special, incidental, or consequential damages associated with flights being delayed or canceled. JetBlue, my understanding is, did refund the 3 tickets at $193 a piece, as kind of an offer of to sort of goodwill, I suppose. But that nevertheless, here we are. So I have a few more notes here, but I understand there's a lot. Both sides filed quite a bit of exhibits that I've reviewed, but that's sort of the top line summary based on my review of everything. So with that in mind, I'll swear in the parties. So I'll start with you, Ms. Barraza. If you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay. All right. Go ahead.
So everything you said is the gist of why we are here today. And I am here because this was not a force majeure event. Yes, there was an initial ATC delay. And I mean, JetBlue conveniently allows for an ATC delay to then be kind of the major reason for a cancellation if it's a part of the list of delays, as long as the subsequent delays are reasonably related. And so I would be interested to know how a thunderstorm in Boston is reasonably related to a part missing from a jump seat on the airplane in Seattle, and how that can be the ultimate cause of the delay. And that's the reason that I brought this forward, is because if it was force majeure, obviously it would be something that I would just have to deal with, right? But because it wasn't, and we were significantly delayed, and I had to make the best decision for my family to get to this event in time, we ended up having to panic buy flights, competing with 200 other people looking to buy flights to Boston, and ended up with over $4,000 in flights, as well as missed Airbnb and rental car. And so I took all of those fees and I subtracted out the credits that they gave us, and am just looking to be made whole.
All right. Thank you,
Whole.
Ms. Barraza.
She mentioned a hole and units. Units entering holes.
All right. I do have a few follow-up questions for you, but I think it makes more sense to first swear in Mr. Is it Pugmire?
Yes, Your Honor.
All right, Mr. Pugmire, if you could please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes, I do.
Okay, go ahead, sir.
Thank you, Your Honor. I just wanted to clarify that the force majeure is not the biggest issue here, although that is part of the reason for the delay. Section 25 of JetBlue's contract of carriage governs situations where a scheduled flight is not operated regardless of the reason or the underlying cause. Under that provision, the passenger's remedies are limited to either transportation on another of JetBlue's flights on which space is available in the same class of service at no additional charge, or a refund of the unused portion of the ticket. So it doesn't matter that it was a force majeure, that it was a seat issue, that it was weather. The bottom line is Section 25 contract of carriage agreed upon at time of purchase is that we'll either transport you on another flight or offer a refund. We fulfilled our contractual obligations. We scheduled her on another flight. We do understand that that flight would not have arrived until Saturday. It would have caused her to miss the tournament, but that was the flight we could offer. She then opted for the refund and scheduled other flight arrangements.
All right. Thank you for that. And I'm curious. So my view also kind of zeroed in on that Section 25 of the contract of carriage. Although I am curious, because it kind of helped me get a fuller picture here. A lot of the exhibits submitted do go into cause of delay being controllable or uncontrollable, and whether they are reasonably related to each other if there's subsequent reasons for delay. How does the type of delay, whether it's controllable or uncontrollable, what is the effect of that? Does that change what JetBlue offers its passengers, or what is the relevance?
Yes, Your Honor. The controllable or uncontrollable relates directly to the customer bill of rights and what type of compensation we offer. If it's delayed for a certain amount of time, we offer a certain amount of a customer bill of rights credit, travel credit. If it's delayed a certain amount of time, we offer food credits, vouchers, things like that. If it's delayed overnight, we offer a hotel. So the controllable, uncontrollable is deemed part of the compensation for that is part of our bill of rights. Then section
so
25 is independent of if we end up not operating, here is what we're obligated to provide.
okay, so I saw somewhere in the file, there's a August 1st email from JetBlue indicating meal expenses up to $12 per meal, ground transportation up to $75 to and from a local hotel. Those sort of kick in depending on the status of a controllable or uncontrollable delay.
Correct, Your Honor. And if they had taken that flight, then a hotel possibly, because the flight wouldn't have flown till the following day in the evening, then there would have been a hotel. And there were notes in the reservation about when the plaintiff described or explained at the airport, we booked on another airline, they advised then the hotel that we would offer no longer applies because you're no longer listed on our flight. So.
Okay. All right. So then if there's a, let's say there's a controllable delay that results in a canceled flight, per the customer bill of rights policy or whatever that is, there would be certain travel credits, certain reimbursement of expenses that passengers would be eligible for, provided that they are rebooked on a JetBlue airline. Does that sound right? Okay.
Yes.
All right. Thank you for helping me understand that. Okay. So Ms. Barraza, back to you. I understand that what you filed, I think most recently too, in response to documentation that JetBlue provided, you're responding specifically to the notion that the JetBlue flight that was offered as the alternative essentially wouldn't work with your plans, your whole reason for going to Boston. That's why you had to incur some of those incidental consequential damages, costs associated with your decision to purchase a ticket immediately through another airline. And that what was essentially being offered by JetBlue simply didn't work with your plans. And I understand that. I understand what you're saying. I'm not saying you're wrong. What JetBlue is focusing in on is that contract of carriage, which does sort of outline that in the event of a delay or a cancellation, the passengers' remedies are, as Mr. Pugmire, sorry, Mr. Pugmire was indicating, you get a refund on your tickets, or you get rebooked at no expense on a JetBlue flight, and that there's that language in all caps that carrier shall, well, this part's not, but carrier, so JetBlue shall have no liability or responsibility to any passenger as a result of the failure to operate any flight. All caps, under no circumstances shall carrier be liable to any passenger for any type of special, incidental, or consequential damages. I understand those special, incidental, consequential damages, those are sort of legalese terms. They essentially mean costs that you incur as a result of the occurrence of, in this case, a failure to operate a flight. But do you have any response specifically to that provision of the contract, separate from the reason for the delay, the contract that you agreed to when you purchased tickets, indicating that if there's a delay, you're entitled to flight refunds or being put on another JetBlue flight, and really nothing else if you elect to go on another flight. Do you have any response specifically to that, ma'am?
No, I think my question would be around that is like, what is the difference between a direct damage versus a consequential or incidental damage?
Yeah, understood. And again, this is where these are legal contracts, and frankly, I usually don't read these types of stuff myself. So what that basically means is, what they're saying there is that incidental or consequential damages, it's kind of what these terms are essentially indicating is that damages, so costs incurred as a result of the delayed flight. So in your case, kind of my thinking here is, in your case, it's exactly what you're alleging, right? It's costs associated with booking another flight at the last minute when competition is high and that price skyrockets, losing out on your, one night of your Airbnb, of your car rental, things of that nature. Those are damages that are of consequence to the flight being delayed. And so when you agree to that contract of carriage, you're essentially agreeing that, your remedies, if there's a delay or cancellation, are limited to what JetBlue is offering, which is that full refund, or putting you on another JetBlue flight, as well as some reimbursements if you do elect to do one of those things. Does that make sense?
Yes.
Okay. All right. So on that basis, ma'am, so I'm gonna rule in favor of JetBlue here, and dismiss the claim against them, given what's in the language of the contract of carriage. So I understand this sounds like it was a very frustrating experience for you and your family. And unfortunately, when it comes to your legal remedies, though, those are costs that I can't award you in a small claims judgment.
I do want to say when we went to the counter, they did tell us that we needed to cancel our flight in order to receive the compensation for hotel and like car and that sort of thing. And so I don't know if it was just misspoken or we misunderstood, but that was part of why we went ahead and cancellation. And I'm also a little bit interested to know why there is the piece of the failure to operate as scheduled that is point C that speaks of the force majeure, and why, like, it's just unfortunate that like corporations can take advantage of people in this way.
Well, I think the reason of the flight being delayed, either controllable or uncontrollable, it sounds like that goes to whether some passengers, the extent that they get travel credits and reimbursement for some associated expenses, to whether it was a controllable or uncontrollable event. It sounds like that's more of the that's what that goes to, which is separate from what you're asking for, which is judgment in favor of you for essentially paying back some of those other consequential damages associated with the flight, the canceled flight. So again, I think that issue is a bit separate from what you're asking for, which is recovery of costs associated with the trip. All right, so I'm sorry, ma'am. I know this didn't go the way you probably wanted today, but legally, again, I don't find that there's a basis for the judgment, so I'll rule in favor of JetBlue. And thank you both for your time this morning.
Thanks for your time. Thanks for showing up, Mr. Pugmire.
Thank you. Thank you, Your Honor.
Thank you, Mr. Pugmire. That is that. Thank you, guys. I know it was a quiet evening, but we'll be back tomorrow for members only on a Sunday evening later. Okay. Probably.
Oh, you're not Chase.
Judge, you're still there?
And Denise, thank you for being here today.
Thank you for being here today. I appreciate it. My name's not Denise though, but I'll forgive you. Probably 5 p.m. Pacific. So like 8. That's what I think. Okay. What's next? I don't know who else is on. You guys go find somebody to watch. I want you to have a wonderful day. Do me a favor. Remember that I love you and I'm proud of you. And I will see you in the next video. Oh, you could sleep. I'll see you in the next video. Okay, bye. Bye.
Ways down and ready to ride.